Thanks, Tom. Good morning, everybody. Welcome to Employing Employees 101. Hopefully you're getting some nice rain where you are if you require rain, or hopefully the weather conditions are exactly how you like it at this time of the year. We're expecting a storm in Tamworth shortly, so we'll get cracking before we lose any power. This office is notorious for losing electricity. So we've entitled it Employing Employees 101, not an easy gig. There's a few traps these days in employing people and getting rid of the ones that we don't want in our organisations anymore. The Fair Work
and advice on the code standards and guidelines.
Fair Work Commission's making it a little bit harder than normal to these days when employing employees. So we'll just go through some of the basics today. First up, let you know the agenda for today. So I'll just speak briefly about who I am. We'll talk about the modern awards and how they'll apply to you. Wages versus salary and rates of pay, how to calculate those if you don't know how to do that or you're having difficulty, because there has been a few changes. The difference between full-time, part-time and casual employees, leave entitlements and how they're applied, probationary period versus the minimum employment period, that's an important one, and procedural fairness to negotiate and to negate having to go through an unfair dismissal. So they're just the basic topics for today. You'll notice too that there's a disclaimer saying that the information is general in nature and should not be taken as personal advice, because every operation is different. Every operation has different scenarios, so there's not a one size fits all. It's not a cookie cutter operation. So the information I'm giving today is based on the Fair Work Act as it stands, and also I'm assuming that the majority of you all fall under the Pastoral Award 2020. So just a little bit about myself, Wayne Schwalbach. I'm based in Tamworth, but I do travel around Australia assisting my clients with any industrial relations issues. Difference between industrial relations person and a human resources person is human resources basically does the hiring and firing and basically assists the management with the running of their employees. Where an IR specialist myself, I spend the majority of my time interpreting the awards because, excuse me, the awards do change from time to time. There are some big changes coming in February when the government's, I think they're at their second reading now. They'll be declaring some new things, some new changes. A lot of it's around casual employees. So the way we hire and terminate casuals now is going to change. The way we do casual conversion is changing as well. So that hasn't been made too public yet, but I'll be able to give you a little bit of information about that. So my job's to do that. I also have clients, and it's nice to see a few familiar names up there on the screen that I represent, so that before they terminate somebody or if they have a question about their award, they speak to me first, and we try to avoid ending up in the Fair Work Commission. If we do end up in the Fair Work Commission, well, it's my job then to defend them. Also in the pastoral industry of late, the Fair Work Ombudsman, which is another different organisation, they've been handed some extra money in the millions of dollars to do some raids on different places. When I was up in Toowoomba last at the Cotton Conference up there, they were up in the Lockyer Valley looking at all the horticultural people. So the time will come shortly when they'll be visiting more of those that fall under the Pastoral Award. At the moment, they're actually concentrating on those in the hospitality industry, being that it's this time of the year. So that's a little bit about myself. So modern awards and how they apply to you. So what is a modern award? There are now 122 modern awards in Australia under the federal system, down from 1,212. So back in 2008, 2009, the government at the time cancelled Fair Work Australia and made it the Fair Work Commission, and their job was to modernise the awards. So a lot of awards amalgamated into one of the 122. So there's a few unusual awards. If you're actually looking for hiring a trolley collector, for example, those that run around the supermarkets, you'll actually find them under the Vehicle Retail Maintenance Award. So why they ended up there, who would know? That's not my job, but that's how crazy some of the system is. So the modern award, there's 122 of them. The one that would apply to all you people in the cotton industry is the modern award, is the Pastoral Award 2020. So that's to do with anything from cropping to spraying crops to fencing, anything to do with farming falls under the pastoral award. So in the pastoral award, for 99% of you, there are only 3 classifications that you need to worry about. That's Farmhand level 1, Farmhand level 3, and Farmhand level 5. All the other ones only apply to feedlots or dairy operations. So normally for Farmhand level 1, that's somebody in their first 12 months with you in the company, in your organisation. They're normally led by the hand. They're told what to do on a daily basis or given a list of what to do, and off they go. A Farmhand level 3 is normally after the first 12 months, providing that you can sort of basically give them a week's worth of work and let them go on their own with a bit of supervision. And then Farmhand level 5 is basically for your leading hands, those that have control over other staff. You might have a station manager or a supervisor in different areas. So that's the only 3 that you need to worry about, Farmhand levels 1, 3 and 5. The National Employment Standards, there's 11 of those. That's all to do with your annual leave, your carers leave, sick leave, personal leave, all the same thing. All to do with community service leave, to do with family and domestic violence leave. So why we have the National Employment Standards is because instead of having to write something into the 122 modern awards, which would be time consuming, and then you've got to let everybody know about that, just from time to time, they adjust the National Employment Standards. So had I been giving this presentation this time last year, I would have told you there was 10. We've now moved to 11, of course, with the new family domestic violence leave, which was in last year, but the rules have changed around how that operates. So that was added to the National Employment Standards. So that means it covers every award. It's also something that you can't change as well. So you cannot have an employee and say, look, I'll pay you $100 an hour instead of the $25 an hour, but you're only going to get 15 days annual leave or 8 days carers leave. Doesn't work. It's not lawful. You're not allowed to do it. They're the National Employment Standards. The next one that confuses a lot of people is the Fair Work Commission versus the Fair Work Ombudsman. 2 different entities, brother and sister. They fight all the time. If you're privileged enough to read some of the decisions that are handed down in the Fair Work Commission, quite often they're having a little bit of a dig at the Fair Work Ombudsman. So the best way to explain how that works is you're driving to work this morning, assuming that you don't live on the property, and you get pulled over by the constabulary on your way to work, and they issue you with a speeding ticket, and you deny that you wanted to speed. Normally you just can't walk into the local magistrate and say, you know, I need this fine sorted. You've got to go and find yourself a lawyer or solicitor. And that's basically what the Fair Work Ombudsman is. So if you've got an issue with an employee or an employee has an issue with you, or they want to ask a question, they would go to the Fair Work Ombudsman. They don't go to the Department of Fair Trade. The amount of times I hear that, you know, they've reported the business to the Department of Fair Trade, different entity, different jurisdiction altogether. So the Fair Work Ombudsman offers advice. The Fair Work Ombudsman also has the power to come out and inspect your books and records. They're looking for timesheets, they're looking for rates of pay, and they're looking that you haven't breached any of the Fair Work Act, and in particular, in your case, the pastoral award. The Fair Work Commission, that's the scary one. That's where you go up before a commissioner or a deputy president should somebody file an unfair dismissal against you. The Fair Work Commission also are the people that decide each year what the minimum pay rate will be for the following year. So that's the difference between those 2. Very rarely would an employee ever speak to the Fair Work Commission. They'd only be dealing with the Fair Work Ombudsman unless you have a matter before the Fair Work Commission. A few things to know about your pastoral award. Your what I consider one of the easier awards to understand. It's basically straightforward. One of the beautiful things from an employer's point of view about the pastoral award is the overtime. In your award, as well as the horticulture award, and I think there's only about another 3 awards out of the whole 122. When it comes to overtime, you can work your employees Sunday to Saturday over a 4-week period of not more than 152 hours before you incur overtime. That applies to full-time staff and casual staff, nothing to do with part-time staff, and we'll talk about that in a few minutes' time. So basically what it is, you draw a line in the sand, and my suggestion is we're coming up to December very shortly. You kick that off as week 1, sorry, if you're not already doing it. So every 4 weeks, you can work your employees up to 152 hours before you incur overtime. As I said, for part-time and casuals only. Do casuals receive overtime? Yes, they do. Other things about the pastoral award, as I said, you've got levels 1, 3 and 5. Everything else is pretty stock standard with everything else. A casual has a minimum start of 3 hours, just like just about every other award. How do you look at your classifications? You'd bring up onto your computer the Fair Work Commission's website, and then you go to My Awards, and you bring up the Pastoral Award 2020, and then you go to classifications. And as I've said to you, yours are all pretty simple, 1, 3 or 5, but it does give you a little bit more in depth of what's the expectations of people to go up to the next classification. If you happen to have a feedlot or a dairy operation on the side, of course, you'll need to look at those other farmhand levels as well. I'm happy to take questions. I've got the chat site open on the side, so if there's a question or if I'm going too fast or I say something that doesn't make sense, more than happy to take those questions, or you can leave them and save them till the end. Wages versus salaries versus and rates of pay. So wages, so for a wages staff member, they obviously work on an hourly rate. They have overtime. So for a full-time employee, ordinary times earnings or ordinary times is 38 hours. And then you have overtime after that. But as I said, in your award, you're allowed to work them up to 152 hours in a 4-week period before you incur overtime. So say, for example, this week you need to work somebody 60 hours because the weather's fine and it's time to start getting your crops off. That's fine. And then next week, a bit of a storm comes in and they only work to 20 hours. So long as you average it over the 4 weeks to 152 hours, anything over 152 hours, you'll have to pay the overtime rate. There is a way around that, and it's called a flat rate. A lot of cotton farmers and people in the pastoral award use the flat rate system, and that's normally done by what's called an IFA. So it's an individual flexibility arrangement or flexibility agreement. So that means that individually, so every employee is different, but with an employee, you can vary 5 things. You can vary their working hours without penalty. You can adjust their overtime without penalty. You can adjust their penalty rates without penalty, their allowances without penalty, and one that I've never seen used, but it's in the system there, you can adjust their annual leave loading if they're a full-time employee or a part-time employee to change it for the 17.5%. With an IFA, you don't have to register that with the Fair Work Commission. It's just something you do between yourself and the employee. But you must keep it as a pay record, and that's one of the first things the Fair Work Ombudsman Inspector would look at when they come in. And most importantly, if you're going to put somebody onto an IFA, if you're going to put them onto a flat rate, they must pass the boot being the better off overall test. So they need something in that individual flexibility arrangement that stands out over and above the modern award. So a tool you can use. Personally, I'd seek advice before you do them. I've got a matter up in Queensland at the moment where an IFA hasn't been done correct. We probably would have won that matter had it not been for an IFA error, and the female commissioner has asked to have investigated a little bit more. So we just need to make sure that if you're going to do an IFA, that you do them properly and that you put it under the pastoral award and not something else if you've got other employees. I should mention too, if you're a larger organisation and you have some bookkeepers or payroll clerks or something like that, they don't fall under the pastoral award. They'd fall under the private clerk sector award. So you just need to be aware of that. So if you're a big organisation, they won't fit under the pastoral award. My suggestion is, again, when you go onto the Fair Work Commission site and bring up the pastoral award, the first thing you should look at is the word coverage. It'll be over on your left-hand side. You click on coverage, and that tells you exactly who in your organisation can become a under the pastoral award and who doesn't. Likewise, if you have truck drivers on your properties and they travel more than 200 kilometres per day, 500 kilometres per day or 200 kilometres interstate, they'd actually fall under either the road transport award or the long distance road transport awards. So you need to be careful with that as well. With a salary is a boot test. Again, you have to make sure. So if you're going to employ somebody and you start me, for example, on $80,000 a year, that's my commencing salary. You need to do a boot test. So you basically need to work out how many hours I'm going to do in the year, roughly, and make sure that at least I get at least grade or Farmhand level 3 or Farmhand level 5. So you need to be a little bit careful about that. So that's what you need to be careful of. Salary versus expectations. At the moment, unfortunately for the employer, it's an employee's market. Currently, there's I'm receiving a lot of calls from people asking me to try and help find staff for them. Not something I do, but I have a sister company, Jobs Australia. They're a labour hire company. Any of those could help you with staff. But it seems to be at the moment that a lot of people are struggling to find employees and they're having to pay top dollar. So long as you meet that minimum requirement, the minimum pay rate, you'll be fine. Now, in all awards, it talks about ordinary hours of 38 hours plus reasonable additional overtime. So what is reasonable overtime? Reasonable overtime is a two-way street. One, for the employer, reasonably that you require your employees to work for you on overtime because, for example, you've got to get a crop off or there's something within the business that needs to help. The next thing you need to be careful of from the employer's point of view is that you haven't worked them 8 or 12 hours and they're likely to fall asleep at the wheel any longer because work health and safety will trump us all there and they'll come in and almost send you broke if it can be proven. Also, the example I use too with reasonable overtime is if you're the coach of the under-14s footy team and they train on a Thursday after hours, say from 4 to 6, will it be unreasonable for your employer to expect you to work on that Thursday? You might be able to work the Wednesday or the Friday or some other time, but you have what's called carers' responsibilities. There's now flexibility in the workplace, so therefore you need to be considered that there's what's called reasonable additional hours. Just a couple of questions here. Is it a legal requirement to pay leave loading of 17.5%? Yes, if it's in the award. Everything's governed by the award, so yes, 17.5% needs to be paid. That's part of the National Employment Standards. How can I give an example of how an IFA might deal with overtime? So, for example, Bob's working for you and he's on $25 an hour. You've done the calculation and overtime's going to cost you $28, $29 an hour. You might just round off an IFA to $30. So for the first 38 hours, Bob's getting an additional $5 per hour, but that $30 should cover the overtime. So it's sort of like a cost averaging thing. But as I said, in your award, Liz, you can have what's called the 152 hours over a 4-week period before you need to worry about overtime. So if you work your rosters out cleverly, you can sometimes have it that you don't have to pay overtime at all. There's a web page for the Dairy Agricultural Society that says that they've got a dummy roster. I noticed, interestingly, that it has an employee off on a Monday, Tuesday. I don't know what properties can afford to do that. So, but yeah, IFAs can be manipulated to help you and to streamline your bookkeeping, your payroll system. But as I said, you just have to make sure that you pass the boot, the Better Off Overall test. Rates of pay, so there's a minimum hourly rate. So if you've all got a pen or something there, I'd suggest you write down FWO, so F for Fred, W for William, O for Orange. That's Fair Work Ombudsman minimum pay guides. And the page will come up and there'll be an alphabet along the top. You'll click on P for pastoral. And then you'll find the pastoral award and it'll come up under the PACT, which is the pay and calculator tool that the Fair Work Ombudsman uses. And in that is all your pay rates for every grade. It talks about overtime. It talks about Sundays. I think they even talk about Christmas Day these days. So some awards have got a different rate for working Christmas Day and Good Friday. And it also talks about in the pastoral ward whether the overtime's to deal with watering of stock, livestock, or whether it's just for working with ordinary work. So you just need to do that. Yeah, leave loading for a casual is 25%. So I'm talking about annual leave loading. So when somebody goes on annual leave, so we're talking about full-time and part-time people, that's 17.5%. For a casual, yes, you pay 25% casual loading. But if you go to that Fair Work Ombudsman's page and you use those sheets, that's already got it calculated for you. And I like to use that. So if ever anything, the Fair Work Ombudsman comes in and says, well, you're wrong, you just refer them to, well, here's a printout of your page. This is what you've said. Even though they've got a little disclaimer at the bottom, I'd be making sure that you've got a copy of that. So your qualifications and classifications we've already had a look at. So the annual wages decision from the Fair Work Commission. So they've already started, believe it or not, for the year. There's a panel. There's normally 3 commissioners or deputy presidents from the Fair Work Commission, one of which includes the president himself. Normally they have a professor of economics, and then they have what they call a layperson, so somebody who's basically just off the street or in the industry. And they call for expressions of interest throughout the year. So you have your union saying that everybody needs a $55 a week wage increase. You'll have the employer saying, no, we can't afford that. We don't want any wage increase. And it just goes backwards and forwards till about the first week of June, when all the submissions and all the hearings are closed. They then all meet again and they make a decision, a little bit like the RBA with their bank rate decision. Then in second last week of June, they do an announcement. Normally it's broadcast over Teams or Zoom or something like that, and they'll give the wage increase, which this year was 5.6%. You then need to wait until the first full pay period to pass on that wage increase, noting that I just said it's the first full pay period. So if the 1st of July turns out to be a Wednesday and your pay run doesn't start till a Thursday, you're not expected to pro-rata or backdate anything. It's just from your first full pay period. So in some organisations, the wage increase doesn't commence till around about the 14th or 15th of July. From the 1st of July to that Fair Work Ombudsman's page I told you about with the minimum wages on it, that will be updated, and it'll tell you right up at the very top that this commenced on such and such a date. And again, they re-emphasise that it's from the first full pay period. So that's all you have to worry about that. Just having a look. G'day, Paul. Hi, Wayne. Although still under review in its current form, can you outline how the proposed legislation same job pay could impact growing businesses? We entered into Parliament early next year. So yeah, there was the same job, same pay that came out from the new Labor government. They've instructed the Fair Work Commission what to do. Now they've got one called closing the loophole, because of course with just about everything that everybody ever does, everybody tries to find a loophole, and they've found a few little nasty loopholes in some of the awards, so they've got to go back and change those. You and I, none of us, not even a parliamentarian, can change the Act. It has to go through Parliament to the Attorney General, then they issue a decree to the Fair Work Ombudsman to go and sort it out. So in its current form, same job, same pay. This, of course, is designed for all the 122 modern awards. You guys, I believe, would be a little bit different under the pastoral award. Some people have got skills. They can you can put them on a header and go out and do cotton. Other people, you certainly wouldn't send them out without supervision. So that'd be unfair to have the same job, same pay. What has complicated the matter is up until the middle of this year, you used to be able to slap somebody on the wrist if they were telling their fellow workmates how much they were earning per hour. Now that's unlawful to do that. And as a matter of fact, if you have that clause in your policies and procedures or in your employment contracts, it's a $10,000 fine now. So if you've got them in there, you'd best be losing them, getting rid of them all, because that's now unlawful. So something to be a little bit careful of there. While I'm thinking about it too, you will have heard me say that for ordinary times earnings, it's a 38-hour week. So funnily enough, this year is the 40th anniversary since 40 hours a week got abolished and back to 38. But you've got no idea the amount of people that bring me up and still talk about 40 hours per week. So it's 38 hours for a full-time employee, up to 38 hours for a part-time employee. And I'll go through that on the next slide. Also too, I don't want to scare anybody, but if you're paying superannuation on all hours, you're ripping yourself off. You only have to pay superannuation on the ordinary hours of 38 hours. And that's all you really have to pay it on. You don't need to pay it on the 60 or 70 or 80 hours, whatever they're doing. So those that use Mileband, Xero and all those other electronic ones, you just need to make sure that you've got the right boxes ticked. A lot of clients I've come across lately, and particularly up in Toowoomba, were telling me they pay super on all. Are you going to be able to claw that back? No, not without a lot of difficulty, but you'd be just informing your employer that there's been an administrative error, and from here on in you'll only be paying on 38 hours, which is what you're required to do. I guarantee you though, 99% of people don't even know what they get paid into the super until they're about my age. So here we are at full-time, part-time and casual, the differences. So a full-time employee, they're employed for 38 hours a week, okay? They're expected to turn up each week for 38 hours. If you've got no work for them in the 38 hours, that's your bad luck. You still have to pay them for the 38 hours. Reasonable overtime, I've already mentioned, so it's got to be reasonable on both sides of the coin. And as of last month, if you're forcing an employee to do reasonable overtime and they don't want to do it, or they can't do it, or they can demonstrate that they can't do it, and you insist that they do, they can now go to the Fair Work Commission to have it arbitrated, which is something I don't recommend you do. Just have that conversation with them and try and come to an amicable arrangement. We've already touched on the ordinary hours and rostering, so for 152 hours over a 4-week rolling period. So if you can fit your staff into that, and I know your farmers say you do a lot more than the 38 hours a week, but if you can roster it somehow that you can do the 152 hours, you'll save yourself some overtime. And in the event anyway, unlike most other awards where overtime's calculated daily, it's only when you get to the 152 hours would you be paying overtime. So if you've got somebody that's done 200 hours for the month, you'll only be paying overtime on the difference between 200 and 152. The most dangerous employee, in my opinion, is the part-time employee. So there's somebody that works less than 38 hours a week. But the kicker here is that they're on a fixed days and fixed start and finish time. So you're hiring me today. Welcome along, Wayne, to my organisation. We're going to employ you as a part-time employee. I need to know that I'm working Monday, Wednesday, Friday, Saturday, and my hours will be 7:30 till 3. So if somebody who works for you is unwell off for a few days and you need me to do or work hours outside those fixed days and fixed start times, the entire shift that I worked at is on overtime. Unless within 2 weeks notice prior to that, you can enter in an agreement with them that they'll need to change their hours or working week for some reason. So, one of your leading hands or something might be going on holidays. You know they're not going to be there for 2 weeks and you really need me to work on that Thursday, which is not my rostered time. You can enter into an agreement which just quite simply says that Wayne has agreed to work these extra days at no penalty rates, and then I just work those extra hours. 38 hours for your full-time employees. They get 20 days annual leave per year and 10 days sick leave, carers leave, personal leave. It's all the same thing. If I had $1 for everybody that's rang me up to complain about their employer that they've used all the sick leave and now they want to go on to carers leave and he won't pay it or she won't pay it, it's amazing. It's all the one thing. And the reason they call it carers leave these days is that if you are flatting with somebody, you've got a flatmate, they don't necessarily have to be a spouse, and your flatmate becomes unwell and they need somebody to mop their brow or hold the bucket or something for them, you can actually take that day off as a carer's leave. Do you still need a medical certificate? Yes. I can't get into doctors. It takes 3 weeks to get into doctors. That's okay. will accept a statutory declaration.
Down on the code too.
Yeah. Also, there's an urban myth out there, and I'll come to urban myths in a moment, that you have to wait 2 days to ask for a medical certificate. That's untrue. You can actually ask for one up to 50 minutes. If they go home 50 minutes on a Friday and you believe they're not unwell, you can certainly ask for a medical certificate. So back to the part-timer, they accrue pro rata entitlements. So for example, you've just hired me and I'm working for 20 hours per week. When it comes to annual leave, yes, I still get my 20 days off per year, but I only get paid at the 20 hours, not the 38, plus my 17.5% holiday leave. So you still get the same amount of days, same with sick leave, still get the same, but instead of paying the 38 hours, I only get paid the 20. Right, the casual. So this is how the casual employment stands as of today, the 29th of November, 2023. I'm telling you now, it's going to change, and it'll be changing in a big way. What those final details are, I'm not sure. So a casual employee is an employee who you employ on an ad hoc basis. So you hire me today, you terminate me today. The Fair Work Act actually says that you have to pay me today. Nobody does, don't worry about it, just pay it on the normal cycle. No one's ever been prosecuted about that, but that's how a casual works. Hired today, terminated today. You might want me tomorrow, you might want me on Friday, you might not want me for 2 weeks. There's no guarantee of any future ongoing work for me, so technically my shift stops as of 5 o'clock today when I knock off, and then I just get re-engaged the next time. For that, the casual has a right to decline a shift. So Wayne, I don't need you till Friday and I've got a second job or I've got something else on, I can decline that shift. Are you meant to harm the employment by asking them or insisting that they have to work? No, you can't. You cannot do that. So that can't happen. Minimum engagement, as I said, for a casual is 3 hours. So for all this, they get a 25% loading on top of their hourly rate. And that's to cover things like they don't receive annual leave, they don't receive carers leave. When you terminate them, they don't get a termination pay, they don't get in lieu of notice. Their employment just ceases, full stop. Get asked lots of times, does a casual receive overtime? Yes, they do. Again, they're only to work 38 hours until they go into overtime. But as I said, in your industry, you've got the 152 hours. Casual conversion. So casual conversion is currently for a small business. So in other words, a small business is an employee with less than 15 employees. So in other words, 14 or less. And that includes the owners of the business. Doesn't matter about your turnover. Your class is a small business. Currently, you don't have to do casual conversion. You can just keep them on as a casual. If you have more than 15 employees, you're known as a larger enterprise. And once a casual has worked for you for a 12-month period, and it can be proven that they worked regular and systematically in the previous 6 months, you must offer them at least part-time if they're doing less than 38 hours a week, or full-time if they're doing more than 38 hours a week or consistently. What is regular and systematic, I hear you ask? In the bad old days, we used to just get a casual and we'd work them Monday, Tuesday, Wednesday, 9 to 5 1 week, and then we'd switch around to 7 to 3 the next week and just swap days and swap times to avoid being regular and systematic. There's been a High Court ruling. Regular and systematic, first of all, the Fair Work Commission wants to know, is there a roster around? So have you got a roster on your staff room, or do you send out a roster once a month saying, do you weigh your hours for the following 4 weeks, or 2 weeks or 1 week? That is classed as regular and systematic. It doesn't matter that I didn't work every Monday, Tuesday, Wednesday, Thursday, and that my days got switched around. Still classed as regular and systematic. So please don't fall into that trap. Just looking at a question now, if we have wet weather and they choose not to come to work, even though we might have wet weather, Jocelyn. No, if they're employed, if they're a full-time employee, they're required to work. Some awards have a wet weather allowance. I don't believe there's one in your award. There's one in the quarrying and cement and lime award, but I don't believe there's one there for you. So if you've got work to be done and they're a full-time employee and it's part of their 38 hours a week, yep, you can ask them to work. If we don't have the work, then we have to ensure they are paid for the 38-hour week. Correct. Yep. And this happened a lot during COVID, which is why the Fair Work Commission did in 3 months what normally would take them 30 years to do. When COVID came, and like I've got a lot of carpenters and kitchen cabinetry people, and they obviously couldn't go into people's houses because of COVID and that. The Fair Work Commission ruled that if they're a full-time or a part-time employee, you still had to honour those hours. And that went on for about the first 2 months till half the businesses went broke, and then they brought out the job keeper, the job seeker, and everything else that went with it. So lesson to be learnt there is, if you've got a full-time employee or a part-time employee, just because you don't have work for them is not their issue. You have to pay them. On the other side of the coin, if they're hired as a harvester or something like that, and one of the parts on your machinery breaks down and the part's got to come from China, and the part won't be coming for 3 weeks, so therefore they can't drive the harvester or whatever, you could stand them down because it's an incident that's beyond your control. So just because you've got no work for somebody is not beyond your control. You should have had something in the pipeline for them. But if there's a part or something, a piece of machinery or something beyond your control, floods is another one. If you're flooded, if a flood rips up half your paddocks, again, you could stand them down because that's something beyond your control. Leave entitlements and how they're applied. So for full-time and part-time employees, annual leave, 20 days. You can't vary it at anything. You can't do a clever little IFA to change that. So annual leave is 20 days. It accrues from the day you start. So another urban myth out there that you've got to go 12 months before you can get annual leave. Not correct. Same with your sick leave, carers leave, personal leave, all the same thing. You get 10 days for that. Now, a little tip for you. I've got to go and see the knee specialist on Friday. So when I take time off to go and see the specialist, I'm not on sick leave. It's a pre-arranged appointment. It's not stopping me from working because obviously I'm working today. I'm just going to see a specialist. So therefore, the employee is on what's called unpaid leave. However, if the surgeon, the knee specialist, decides to give me a medical certificate, you have to honour that and you automatically switch them back to sick leave. But if you've got a dentist appointment, a specialist appointment, you've got to travel somewhere, in theory, it's not sick leave. Sick leave is only designed to when you cannot do your job you're currently paid for. Excuse me. Family and domestic violence leave, as you'll be aware, has moved to paid. It moved from 5 days unpaid leave to 10 days paid leave. Everybody gets that, full-time, part-time, casuals. Casuals get it as well. That starts on the day that you start. So if you employ me as of today, I get it from today. It doesn't accrue like any other annual leave or sick leave, but on each anniversary, it goes back to 10 days. So if unfortunately, and I hope none of you ever have to use it or any of your staff have to use it, but if one of your staff needs to access the family and domestic violence leave and they take 2 days, for example, they'd be sitting there at 8 days. Come their anniversary date, it just goes back to 10. It doesn't go to 18, it goes back to 10. Probably one of the most important for you as employers is that should you have an employee that needs to access that family and domestic violence leave, that you do not highlight it on their payslip. So you would pay them just as per normal as part of their 38 hours a week, plus any entitlements or whatever. In the background somewhere, you need to record that they've taken their 2 days or 3 days, however much it is, but you're not allowed to record it on their payslip. Reason being that sometimes these employees need to go to Centrelink, or they need to go to a bank, or they need to show it to some authority, and they shouldn't have it shown on them that part of family and domestic violence leave. So that's very important. That was a late addition. Just like sick leave, you can ask for proof. So you can ask for a copy of a police report. You can ask for a copy of the orders from the court. If they'll give it to you, you can ask the police to give you an event number. Again, that's very highly sensitive. only one person in your organisation should be dealing with that. I wouldn't even give it to the pay clerk to do. You as the employer, I'd be the person handling that. You just attach it to their payroll records so that if it's ever questioned, that you've got documentation that you actually gave it to them. And look, very rarely does it happen, but it will happen. A bit like sick leave, for those of us that put sick leave on our wages slips, not that you have to. You've all got that employee that as soon as 3 hours pops up, they're sick. So there are a few people out there that'll try and take advantage of this, because technically it's an extra 10 days they don't have to work that they're going to get paid for. So whilst you can't put it on their pay slip, you can keep a record in the background. Compassionate leave. So if somebody's been seriously injured and not expected to live, that forms compassionate leave. So you're entitled to 2 days compassionate leave or 4 half days, particularly if somebody's got to travel. So you might pay them for 4 half days and 4 half days of unpaid leave. You can do that. And then if unfortunately they pass away, they actually get another 2 days compassionate leave. So you just need to be careful around that. Compassionate leave is the stock standard mother, father, sister, brother, grandparents. These days, your partners in life, your de factos and your children, and your de factos children as well. So all of this, of course, is listed under the awarded, and I'll tell you that. And if not, it's under the National Employment Standards. Other types of leave, there's community leave, there's volunteer leave. Just be careful with volunteer leave, that if you've got somebody that's in your RFS or your Rural Fire Service or SES or something like that, that's voluntary. You don't need to pay that. They go on unpaid leave unless you want to be an employer that sort of supports that sort of thing, and they've been a good employee to you and you just want to do something for the community. You can always do more than what the award says, but for that type of leave, it's on unpaid leave, and there's a few of those questions floating around at the moment. So that's basically all the leave entitlements. Remembering that for a full-time and part-time, annual leave incurs a 17.5% annual leave loading. The casuals don't get it because, of course, they're getting their 25% all day, every day. One of my favourites, probationary period versus the minimum employment period. So I guarantee just about every one of you would have a probationary period in your employment contracts. Funnily enough, there's no such thing as a probationary period in the Fair Work Act of 2009. It doesn't exist, but all my clients, we leave it in there because we use it as a monitoring tool, because I don't care how good somebody is when they come in for an interview. Everybody these days is sort of taught how to handle an interview, but are they the right person for your business? Are they going to be able to keep up the pretense for a certain period of time? Not always. So we keep it in there. And another trick too is, so you start me off as a level 1 farmhand, and then in 12 months time you say to me, well, Wayne, you're not doing too bad a job. We're going to move you up to level 3, but we're going to put you on another 3 or 6 month probationary period. Cannot do it. You only get one crack at the probationary period, and you'll see in a minute why that makes no difference anyway. So that only applies it from the initial commencement of employment. You can't, when you promote somebody, put them on another probationary period. What is in the Fair Work Act and what saves everybody's bacon from time to time is what's known as the minimum employment period. So if under the Fair Work Act, a small business, as I said before, is fewer than 15 employees, your turnover doesn't apply. So you can be $1 million and have 16 employees, you're a large business, 12 employees, you're a small business, still on the $1 million. So for a small business, so in other words, if you're 15 employees or less, you have a 12-month window of opportunity to terminate an employee without the risk of an unfair dismissal, provided that it can't be proven that you discriminated against them, or that you thumped them, or that you did something that would have harmed them. So the small business, you've got 12 months. So those that think they're on a 6-month probationary period, then they're in the clear and you can't do anything with them. Yes, you can. You've got up to a 12-month window. Likewise, for your medium to large businesses, so that's 15 employees or more, you've only got a 6-month window of opportunity before you come to an unfair dismissal. Everybody happy with that one? So procedural fairness to negate an unfair dismissal. There's a couple of urban myths out there. Probably the biggest one is that you have to give 3 written warnings. No such thing, never has been, never will be. It's a bit like the rumour that you're never more than 3 metres from a spider. Not true, just somebody invented that one day and it just took off. So it's an urban myth. What we have, as I said, is the minimum employment period. So the Fair Work Commission does not expect you to have to go through the same scenario and the same argument with the same employee 3 times before you can get rid of them. But what you have to do is do what's called procedural fairness. So doesn't matter whether your employee has been with you for 1 minute or 20 years. If they do something that you don't believe is correct or is not within your policies and procedures, you need to have a meeting with them. You need to tell them what's wrong. You need to give them a chance to respond to what is wrong. You need to give them a chance to rectify what is wrong. And then if they haven't done it, you issue them with a show cause letter to say, well, why haven't you done what we discussed? If they don't give you a satisfactory response, see you later. So I'll run through that slowly. So, and I'll use 2 scenarios. So we've got Sally in the office, who's the face of your business, and her uniform's disgusting. It's got mayo stains from the salad sandwich she ate last week and all sorts of things, and it's just disgusting. You've talked to her a couple of times. You've had a complaint from a client that, you know, it's not looking really good. So you call Sally in. Again, whilst the Fair Work Act says you don't need to supply or they don't need to bring a support person, I strongly recommend that you allow them to bring a support person. Can't be anybody that's involved in an investigation if it's a disciplinary matter, but they can bring a support person. If they happen to bring a lawyer, the lawyer cannot act as a lawyer. He's only there as a support person. Basically, around a support person, they're only there to support. They're not allowed to advocate. They're not allowed to jump up and down or answer questions on behalf of the employee, although the Fair Work Commission says they don't have to remain mute. So in other words, they can say to Sally, Sally, don't forget to ask about this. Sally, don't forget to say about that. Or, excuse me, Wayne, you can see here Sally's upset. Can we have a 10-minute adjournment, please? So always recommend that you offer them to bring a support person. If they don't bring a support person, on your notes, on your interview notes, just clearly write down that you offered a support person and they declined. Okay, so we bring Sally in and we say, Sally, we've had this verbal conversation a couple of times now about your uniform. What have you got to say? And unbeknownst to us, Sally's washing machine broke down 2 weeks ago. She's a little bit embarrassed about it. So your first question will be, well, how long, Sally, before you can get the washing machine fixed? And she might say, oh, you know, it'll be done in 3 weeks. So for procedural fairness, you'd say, okay, Sally, I'll give you 4 weeks to get your washing machine fixed and be, you know, in a bright, shiny uniform. In the meantime, here's $20 to go to the laundromat or go see the person in the donga next door, and we'll give them some money to wash the uniform. There's always ways around it. But we've found there's an issue with Sally and her uniform. We've now found that she's got a problem as why she's wearing the dirty uniform. So we rectify that. If Sally turns up in 6 weeks' time, still like that, so she's really, you know, having a land of you and she never really did have a washing machine, you'd be quite within your rights to terminate her if you saw fit that way. Probably wouldn't use that one for a termination in the first go, but these are just examples I'm using. The next person you got is Bill. He's in the office and he leaves confidential information all over the desk every day of the week. And someone's commented that, you know, it's a bit rude that they can see my personal informational stuff. So you bring Bill in, you go through the same scenario and you ask Bill, why is it like that? Well, I don't know, haven't got time. So your response will be, Bill, make time and I'll give you a week to fix it up. A week would be fairly responsible to time to do it. So therefore you just give him the week. I'd personally wait 2 weeks. If it's still all over the desk, well, again, you know, give him a show cause letter. Why, Bill, haven't you got this fixed? You know, obviously you're not the sort of person for the business. Away we go. So Paul, for the minimum employment period, 15 staff is 15 staff. Doesn't matter whether they're full-time, casual, part-time. It also includes the directors of the business. And if you're on the borderline of somebody you're terminating, the Fair Work Commission counts the person that you're terminating as well. So if you're sitting on that 15 mark and you say, oh, well, we've only got 14 because Wayne's out the door. No, Wayne forms still part of that 15. Does it apply to casuals as well? Not really, because the casuals, if you're going to get rid of them, you just simply don't rehire them. You just don't re-engage them the next shift. That's the beauty about having a casual. However, if it's going to be regular and systematic, you just need to be a little bit careful about how long they work for. Just give me a phone call. Say, Wayne, I've got this situation. Can you help me out? Remembering too that Cotton Australia allows you to ring me and I give you free advice for the first 15 minutes and just charge it back to Cotton Australia. Michael Murray, and that's pretty big on that. So that's the service we offer. If we need to, if it's something more important, you need to make up your mind whether you want to engage me or not to help you with that matter. And Adam Kay's another big pushing for it all the time, asks me to remind people all the time. So if you ever got a question, and my card will come up on the end there that you can copy down, just give me a phone call. Liz. So for the unfair dismissal part, Liz, can you just write a little bit more information on that for me so I can see what you're asking, please? Just so I give you accurate information. I don't want to give you a bum steer on anything. Most importantly, if you're going to terminate somebody or you're going to have an awkward conversation with them, that you've got appropriate documentation of evidence. So if I get a phone call, even from my clients that have a retainer with me, they know I won't do an unfair dismissal case if they don't have the appropriate documentation, because being that I'm a paid agent, I have to assure the Commission that the matter has a reasonable prospect of success. If we just go down there willy-nilly and don't have the document evidence, so we can't produce exhibits A, B, and C, or 1, 2, 3, I'm putting my livelihood on the line. So I have a little bit more responsibility to the Commission than you guys do. We've gone through the tools of a formal disciplinary meeting, so you need to invite them a support person. I strongly recommend too that you have somebody to be there to take notes. If for nothing more than that the disgruntled employee, and trust me, by the time you finish with the disgruntled, can't accuse you of saying something or accuse you of putting your hand on their knee or something like that. I see it all the time. So protect yourself as well. So termination versus summary dismissal versus redundancy. So a termination is when, at the hands of the employer, so you, the employer, you terminate an employee. So the Fair Work Commission's very firm on that. So if you instigated the termination, that's what's classed as a termination. If they resign, well, that's a resignation. And if you've got a troublesome employee, the best thing you can pray for is that they give you a resignation, because if somebody resigns, they can't file for an unfair dismissal unless, and there's always a catch, unless it's classed as a heat of the moment or a constructive dismissal. And they're one of those dismissals where Bob comes in, throws his keys to the vehicle on the table and says, up yours, I'm out of here, and off they go. You as the employer, believe it or not, actually have to confirm with the key thrower that his intentions were actually to resign. Because the Commission can look at it and say, well, no, it was in the heat of the moment. He probably really didn't do it. And look, 90% of the time, the employer comes back the next day, as if nothing's happened. So be very cautious around a heat of the moment or a constructive dismissal. A summary dismissal, that's an instant dismissal. They're pretty serious. They're for people that have dumped or assaulted somebody or shot at people. I've had a few shotguns fired at people. Theft, dishonesty, that's a summary dismissal. So they're basically terminated on the spot. They forfeit any lieu of notice. All you have to pay them for is their accrued annual leave. And of course, nobody we ever terminate or nobody that ever resigns do ever pay out their sick leave, carers leave, personal leave. We never pay that. The tricky one, and I don't see it too much in the pastoral law, but in a lot of other laws I do, a redundancy. It is never Wayne that is made redundant, it is the position. So the Fair Work Act says that the position must not be required to be performed by anybody at the hands of the employer. So in other words, a little bit hard in the pasture industry, but just say you had a person that milked your cows for you. We're talking about the dairy industry now. And all of a sudden you're going to go out of cows and you're no longer going to need the cows to be milked. That position would be redundant. Okay, you no longer require that position. If they're a full-time or a part-time employee, you're supposed to look within your business to see if there's another suitable position for them at roughly the same pay rate. If you don't have anything like that for them, you will have to pay a redundancy unless you're a small business. So once again, a free kick if you're one of the small businesses, so the less than the 15 employees, but you have to follow the small business code. There's a thing on the Fair Work Ombudsman site called the small business redundancy checklist. So you need to tick each box to make sure that you've provided a genuine redundancy. Providing you can tick yes to all those, it's a genuine redundancy. If in 3 months' time you decide to get back into cattle and you want to run your milking machine again, there is no time limit from when you made a position redundant to when you reinstate it. However, you wouldn't want to get caught out making a position redundant because you want to get rid of me and then 2 weeks later reinstate the position. That won't fly with the Fair Work Commission. So an unfair dismissal list does not apply to a casual or anybody under the minimum employment period unless they file what's called a general protections claim. And I think that comes up on the next slide, or maybe it doesn't. I'll just have a look. No, it doesn't. So I'll just quickly go through the Fair Work Commission's unfair dismissal. So for an unfair dismissal, it's not a get-rich scheme. So the Fair Work Commission's charged with seeing whether you were unfairly dismissed or not, and they had to put you back into the position you were financially prior to you being terminated. So if I was terminated today and I thought there was an unfair dismissal, I'm telling you now we won't get into the Fair Work Commission until probably the second week of January. So I'm unfairly dismissed. If you terminate me today, tomorrow commences as day 1. The next day is day 2. The next day is day 3. Doesn't matter whether it's Christmas Day, Good Friday, Boxing Day or whatever, they still count as a day. So an employee only has 21 days to put in a claim to the Fair Work Commission. Otherwise, the Fair Work Commission cannot hear the matter unless there's extenuating circumstances. So unless I could prove that through your actions, I ended up at the hospital in a not too great position and they institutionalised me, and we see it a lot now. And I was in the fetal rocking position for 10 days, and by the time I got to it, it had gone past 21 days. If there's extenuating circumstances, they will hear it, but that'd be 1 in 1,000. The Fair Work Commission is still choked up with all the Qantas and Jetstar and everybody else that terminated people during COVID. There's a backlog of years of work there, so that's why I'm saying if I was to put in a claim today for somebody, it won't get heard till at least January, possibly February. That's how far behind they are. So for an unfair dismissal, they've got 21 days to raise the claim. Provided that the employee earns less than $158,000 and they've been with you for either 6 months or 12 months, depending on the size of your business, they have a claim. It's a self-cost jurisdiction, so there's a saying, even when you're winning the Fair Work Commission, you lose. So unless you put in something that's frivolous and vexatious, the Commission won't let you charge the other side your legal fees. So the Fair Work Commission will look at the matter. The most they can make you pay is up to 26 weeks, and that's very rare that you get 20. You'll have to pay 26 weeks, and/or reinstatement. They do have the power to make you reinstate an employee. You would, at the very beginning, tell the Commission that the relationship between you and the employee is irrevocably broken. Should you happen to use those words, 9 times out of 10, the Commission will go, okay, so they'll award probably a little bit longer penalty towards you, but the maximum is 26 weeks. So if you ever end up in the Fair Work Commission with an unfair dismissal, you need to make a a financial decision, a business decision, whether it's worth fighting it. Some lawyers will charge you up to 10, 12, most unfair dismissals cost about $10,000, $15,000 to run, depending on who you get. And then if you've got to go from there, it could become a little bit more. So a bit like normal law, where before you can litigate, you need to mediate. The same thing happens in the Fair Work Commission. So your employee puts an unfair dismissal claim in, you'll receive what's called a form 3, which is a response to the form 2. So they will fill in a form 2. You need to respond to as to why you don't believe they're unfairly dismissed. The commission will then assign you a conciliator. So a conciliator is not a member of the commission themselves. They work for the commission, but they're not a jurisdictional member. So they're not a commissioner or deputy president. Both parties go before them. As of the 24th of this month, it's all done via Teams, although you don't use video. And then the applicant will be asked to put his case forward. You're then required to put your case forward. Normally, the mediator will separate you then. He normally goes to the applicant and says, well, what are you wanting? Everybody wants 26 weeks. Then he comes to you and you go, nah, we'll give you a week. And it just goes backwards and forwards. Sometimes, depending on what mediator you get, even though they're not meant to pass judgment, they might tell you whether you're barking up the wrong tree, whether you don't have any chance of winning this, or you've got a pretty good case, just pursue it for a little bit longer in the conciliation. If the conciliation fails, you'll get issued a conciliation failed certificate. Then they'll assign that to a member of the commission. So you'll either get a commissioner. So the commissioner is the lowest ranking, goes all the way up to president. So you have commissioner, you have deputy presidents, and very rarely would you ever get a president. So then you have your hearing there. So that's basically how an unfair dismissal. So maximum they can award is 26 weeks. However, if you fall under what's called a general protections claim, and these are becoming more and more real, people are using this when people don't meet the minimum employment period. I must admit, I do use them from time to time against some employers, naughty employers that aren't my clients. The issue with a general protections is that there's no limit. So you could actually get loss of future earnings. You can do pain and suffering and humiliation and all sorts of things. So I've currently got one in at the moment against a company for just over $1 million because the guy's pretty close to retiring, wasn't on a bad wicket. And through no fault of his own, in my opinion, they've terminated him. So we're asking for his last 5 years of salary plus some pecuniary interest. If you ever get one of those, you've really got to seek some advice because they can become very messy. And if they're not handled correctly, they'll end up into the federal and family circuit court, where even I can't represent in that. You need to be a lawyer. And just to get to, and again, they'll ask you to do mediation before you go into the actual matter before a judge. You're looking between 80 and 90,000. I had a quote the other day from a lawyer that I use, and he wants 85,000 just to examine the papers and get to mediation. So very messy. You just need to make a business decision, ring the right people, and get your ducks in a row to make sure it can't happen. Has been my experience in the pastoral ward in the last 6 months, and I think I mentioned this up in Toowoomba, that the backpackers and the visa workers that you're bringing in seem to be very, very versed on the Fair Work Act at the moment. I did a job for a client way down in the Riverina, and this guy, I would say, knew just about 55 to 60% of what I knew. I don't think it was his first rodeo, even though I went through the Fair Work Commission site and tried to bring up his name and see if there's a listing of a matter, because all matters that go before the Fair Work Commission are public record. If you know how to look, you can find them. I couldn't find it, but he was very well versed on Australian Fair Work law. So a little bit scary, those backpackers. Look, a lot of them are very good, but there's always somebody out there trying to stiff the employer. So I've got a saying: they can be your mates, and they're great workers until the day you have to have that awkward conversation, and things can go wrong. So just to wrap up, telling you how things can go wrong and how procedural fairness and all that sort of works. And it's on record. You can look up the precedent. So there was a South Australian company. The owner of the business had a massive big lorry. He'd go into the fruit and vegetable markets in South Australia each morning, load up his truck with all the fruit and veggies, come back to his depot. Then they get reassigned to the four truck drivers, and they go out and deliver to all the hospitals and hospitality places, restaurants, homes, whatever. One day, Friday night, so funerals, bar mitzvahs, all sorts of things. But that one day came when he had to have an awkward conversation with one of the employees. The employee got the dirt and went to the Fair Work Ombudsman. The Fair Work Ombudsman came out, inspected the business, sorted out what the matter was in about 15 minutes. But whilst we're here, whilst we've been travelling, let's have a look at your pay records. Let's have a look at your timesheets. And they've gone, it's not recorded here where there's an unpaid meal break taken of no less than 30 minutes, no more than an hour. And the owner goes, yeah, no, all the blokes have, they have their half-hour breaks. And the drivers go, no, we don't. And we don't all the time. And long story short, the Fair Work Ombudsman took them to court. The judge at the time said, well, there's nothing on the timesheets to indicate that they've had meal breaks. Therefore, I rule in favour of the employees. He awarded them $298,000 because in an underpayment of wages, you can go back 6 years. So an unfair dismissal, you've only got 21 days to make a claim. An underpayment of wages, you've actually got 6 years. So he went before the court, $298,000. Old mate had to shut his business down. Those 4 drivers lost their jobs. Bloke went bankrupt simply because he didn't record the unpaid meal break on the timesheets. And why is that such an issue? Because in your award in particular, after the 5th hour or the 6th hour, if you can come to an agreement with employees, every hour after the 5th hour that they haven't had their unpaid meal break, they're on 200% of their normal rate. So they're on overtime from hours 5 till hours they finished, and you don't want that. So if you've got timesheets, you use timesheets. Some use electronically, some use sign-on sheets, whatever. Should there be a recording of the unpaid meal break? Most certainly. And I can see you all sitting there in the offices now going, yeah, but we send Johnny out on a tractor and he goes around for 10 hours and never stops. Well, I think he does. He needs to use a tree occasionally, or 9 out of 10 will be a smoker, or they need to fuel up or something. That's when they should be taking their meal break. There's an example of it on the Fair Work Ombudsman's page. If you type in unpaid meal breaks, I think they actually give an example of a person driving a tractor. And also too, it falls under the Work Health and Safety Act. So here I am today sitting before you. Unknown to me, I might develop diabetes in the next couple of weeks, and I could have a hypo or a hyper by not having my regular break. I prang the vehicle into the tree or have an accident, I fall under the harvest or something. Safe Work New South Wales, Safe Work Queensland, wherever you are going to come for you. So you would need to be able to prove that they had a break. Some of them take an esky and have a sandwich and a drink as they go along. I'm not naive enough to know that there are tractors and harvesters out there that have GPS. So let's just make sure that they can be shown to have consumed something so that you don't have a work health and safety issue. There are backpacker pace education. Yep, perfect. Yes, Paul. I had my suspicions about that. Yes, they all communicate. And look, underpayment of wages was hardly heard of until that bloke that was on MasterChef, one of the judges. He got busted for underpayment of wages. Then there come your Coles and your Woolies and your Salvation Armies and your Krispy Kremes. And you've got to remember too, with your Coles and Woolworths, they've got about 300 or 400 people that work in payroll. So if 300 or 400 people can muck it up, the chances of you in your small businesses or medium businesses getting payroll right all the time is not, it's not an easy gig. And if you miss 1 year of a wage increase, you could be well and truly out. Just as I'm wrapping up too, one other thing I was thought about too, when the Fair Work Commission hands down their wages decision, and so the new wage increase goes up the minimum rate, just say, for example, now you're paying me $25 an hour, and the award says I'm only on $20 an hour, and then next year they just award a 3% increase, so the award goes from $20 an hour to $23. If I'm already on the $25 an hour, you do not have to pass on the increase. You do not have to pass on the 3% increase. It's not a requirement. So long as you can show that those employees are on meeting the minimum rate, and when you go into overtime, or if you're going to do an IFA, that they pass the boot. So in other words, you calculate all those hours out that they've worked as per that working paper, and they're above that, the Fair Work Ombudsman can't do anything until you've actually done it. So that's about all we'll cover today. There's plenty of other things, but I don't want to confuse you with anything more. Hopefully you found it useful. As I said, there's some big changes coming in February. It might be March, just depends on how who wants to fight it in Parliament, whether the opposition wants to say, no, this is not going to work. And the unions, of course, have got to get involved as well. So that's my details there. As I said, Adam and Michael and the entire Cotton Australia team allow you to ring me. You just need to tell me your name, your property name, who your area manager is. I just bill that back to Cotton Australia. As I said, I'll give you the first 15 or 20 minutes. That's on their dime. If we need to go further, or you think you need my assistance, we can talk about a package or an hourly rate from that. So here's a 4-week week coming. Rob, yes, won't be far away. And Jason, yes, there's a recording. My understanding is that Tom recorded this, so we did at the beginning. So yes, there will be a recording of that. Again, I just need to stress that what I've told you is general in nature. I go into unfair dismissals thinking this is going to be a slam dunk, and something comes out of the side that you hadn't allowed for, or as in the case in Brisbane a couple of days ago, the lady commissioner asked a question that hasn't been asked of me for probably 10 years, so I had to adjourn it and go and get some information. One thing I won't do is give you information without checking, so if I need to check something, I might have to come back to you. But other than that, that's how I operate. As I said, I do all states and territories. You all do fall under the federal award, so you'd have to be under one of the 122 modern awards. The only people that don't fall under the modern award is those people that are over 158,000. They're called award free. So again, they really can't file an unfair dismissal. But again, you need to check on that before you make a decision. So are there any more questions? Probably confused you all. Right. Thanks, Tom.
Thanks, Wayne. Thanks, everyone, for coming.
You.